Should human genes be patentable? Distinct from other areas of law, intellectual property is arguably most susceptible to the effects of rapid and diverse technological advancement. These effects are most aptly demonstrated with regard to the ongoing discussion within and outside Australia concerning the patentability of genes. The debate reflects the attempts of the Australian legal system to grapple with recent international trends to dismantle some of the more onerous intellectual property restrictions, and the history of increasing intellectual property protection within Australia. Additionally, an analysis in this area provides a valuable opportunity to analyse the conflict of social, economic, and moral rights within the intellectual property paradigm. The Australian Law Reform Commission Report 99 from 2004 sought to illuminate the effects of the current patent system on research within Australia, the Australian biotechnology industry, in addition to analysing the implications current patent laws have on the provision of affordable healthcare within Australia. In Australia, 5 requisite elements must be satisfied before an invention can be considered to be a patentable subject matter pursuant to Section 18(1) of the Patents Act. These include that a patent must be a manner of manufacture, be novel, involve an inventive or innovative step, be useful, and not be secretly used before the priority date of the patent application. At this point, it is important to note that the patentability of specific genetic sequences often turns on the distinction between naturally occurring and isolated genetic sequences. In contrast to naturally occurring DNA, isolated DNA will never be naturally present within a cell in its isolated form. It is only created by artificial means. In accordance with Australian and international law, naturally occurring DNA will not be regarded as patentable subject matter as it does not arise from a manner of manufacture and because it does not satisfy the requirements of novelty and inventiveness. The distinction between isolated and naturally occurring DNA is fleshed out more fully in the table shown. The principle that isolated but not naturally occurring DNA constitutes patentable subject matter is reflected in the report. Recommendation 6.1 of the report explicitly states that genetic materials and technology should continue to be assessed by the same legislative criteria as other technologies. Moreover, the report rules out the possibility that there should exist an exception for patents with regard to genes and genetic technologies. Ultimately, the Australian Law Reform Commission shied away from embracing a new approach to the patentability of genetic materials on the basis that such a course of action would be contrary to long-established international and domestic practices and may conflict with Australia's multilateral obligations. In addition, the report indicated that there was no evidence to suggest that the patentability of isolated genetic sequences were having significant adverse effects on research, the biotechnology industry, and the provision of affordable healthcare. Accordingly, the Australian Law Reform Commission concluded that a major overhaul at this stage would be unwarranted. However, the Australian Law Reform Commission did make some recommendations that could have the effect of diluting current intellectual property protections, namely the introduction of an exemption to patent infringement where the dominant purpose for the use of the patent was an experimental or research purpose, and the incorporation of a generally inconvenient requirement providing some scope for excluding inventions on moral, social, or ethical grounds. And a few additional significant recommendations are listed here. The distinction between naturally occurring and isolated DNA was explored in the case of Darcy and Myriad Genetics. This case refers to a dispute over patents taken out over the BRCA1 and BRCA2 genes, which have been linked to predispositions of breast and ovarian cancer. The decision emerged in a landscape where Myriad's monopoly of genetic testing was becoming increasingly contentious and igniting moral debates over appropriate levels of patent protection. In this case, the appellant submitted that the genetic sequences were not a product of an artificially created state of affairs and as such would not satisfy the manner of manufacture requirement per Section 18.1 of the Act. The Federal Court rejected the appellant's characterization of what constituted an artificially created state of affairs, ruling that the question is whether it consists of an artificially created state of affairs and not whether it produces or fails to produce an artificial effect. Accordingly, the genetic sequences would be regarded as products of an artificially created state of affairs and as such would satisfy the requirements under Section 18.1. Additionally, the court was not persuaded by the reasoning of the analogous U.S. authority, instead preferring to strictly apply the patent requirements set out in Section 18.1 of the Patents Act. In particular, the 5 judges of the Federal Court regarded it inappropriate to have the judgment informed by social, ethical, and moral reasons, highlighting that any significant departure from current patent practices would be more appropriately dealt with legislatively. The Federal Court decision in Darcy and Miria has subsequently been appealed to the High Court, with a decision expected to be handed down in late 2015. This decision should provide clarity to the interpretation of the statutory requirements of patentability. However, even in the absence of any significant judicial departure from current patent practices in this case, it is arguable, particularly in light of the recent community concerns regarding the ethics of such patents and the rapid growth of technology in this area, that further legislative direction is required.